Good evening. My name is Peter Viegland. I'm a partner at the law firm of Wilmer Hale, lead counsel for the Madany Mosque in the federal civil rights action pending before Judge Shea in Hartford. I will confine my remarks tonight to legal propositions that I believe have been overlooked and to facts that I believe have been overlooked and that are both relevant to this council's determination as to whether or not to authorize a settlement payment to Madany to terminate the litigation. I will confine myself, in the interest of time, to 4 points. First, Madany in the operative complaint has asserted a claim under the statute RLIPA, about which we heard last week, that the denial of the permit substantially burdens the free exercise of their faith. This is a count that does not require any proof of discriminatory intent. The key element of this claim is whether the denial of the permit substantially burdens the exercise of their faith. Right now, there's no mosque in Norwalk for the Muslim citizens to go and pray. They have to pray in basements and have women and men in the same room, which is against their faith, in a space that's not oriented to Mecca. There are many other facts that are laid out in our complaint. And these and other facts give rise to a substantial burden. And it is our intent to move for what lawyers call summary judgment on this count, and we believe that we will prevail. If we do prevail, the mosque will be entitled to the following relief: a permit being issued for the original plans back in 2002, not the settlement plans that have been cut back on the space. 2, damages. Damages relating to the delay that they've suffered as to not having a place of worship. They've had to pay rent, to the additional costs they've incurred for experts and the like, and also my firm's attorney's fees. My firm is working pro bono, which means that we are not charging the mosque for our fees. But under the law, if Madany were to prevail in any or all counts, we are entitled to those fees. The fees now are $6 million and running. In the settlement discussions, we have not sought those fees, and we have limited ourselves to just those out-of-pocket expenses that Madany has suffered. The reason I raise this number is I think it is very relevant to the Common Council's determination as to whether it authorizes a payment of around $300,000 when it is facing multi-million-dollar exposure. In addition, they will have to pay their own attorney's fees to defend this. So I think from a dollars and cents perspective, it is very clear that a settlement is in both parties' interests. Madany, because it gets a place to pray, the congregants get a place to pray, and the city, because it avoids what could be ruinous exposure. The predicate to this relief is that the Madany Mosque meets all objective code requirements. It's obvious that it does. Not only is it obvious, we have an expert that's going to come in and say that. And thirdly, in documents produced by the city admits that the mosque meets all code requirements. That's my first point. The second point, I want to address 2 concerns that have been expressed long-term by the citizens of Norwalk and that were part of the 9 reasons that the Zoning Commission gave back in June of 2012 when they denied the special permit application. First, the concern over parking. What do the regulations require? They require 1 parking space for every 5 worship spaces.
Mr. Viegland, we just want to keep time, so you are about 4 minutes and 30 seconds.
Okay, I will try to speak more quickly. The mosque has a capacity of 435 spaces for worship, and that translates into 87 spots. The permit application back in June of 2012 met those requirements. And the Zoning Commission has always, with regard to other applications, applied that 1 in 5 ratio. The only exception is Al Madany back in June of 2012. Why the difference? Since then, Al Madany, to address the concerns of the town, have an arrangement with the local church for 30 spots, and if the settlement were to be adopted, there's a 50% increase in the number of parking spots. Not because it's required, but because the mosque wants to move forward and have a place for worship. Third point, I want to address the concern over traffic. What is the best evidence on what the traffic levels will be? That's Michael Galanti, the traffic consultant hired by Al Madany. He assumed that 175 cars would be entering and exiting the mosque area during midday when they typically have their prayers, and he found no degradation in service. The city's proof is an expert that talks about another mosque in Windsor that is larger and differently situated. I submit to you that that is not very cogent proof. Lastly, damages. The damages here, as I referred to before, are, for settlement purposes, limited to the modest out-of-pocket expenses that Al Madany suffered over the last couple of years. We are not seeking our attorney's fees. My firm is not in this for the money. We are in this because we think it is a just cause. We're not. Please. We're not. And if you look in the paper, my firm typically donates the fees that they win in any civil rights case to various charitable causes. So we are not in this for the money, and in settlement we have not asked for any fees. If this case goes forward, and if we do not settle, our firm will seek fees, and I think that's relevant to the Common Council's consideration of the settlement agreement. Thank you.
Thank you.